Olá, colegas aeronautas! Estou aqui hoje para falar sobre um novo capítulo no processo de recuperação judicial da Azul Linhas Aéreas nos Estados Unidos, o chamado Chapter 11. Nos últimos dias, acompanhamos um fato que chamou a atenção de toda a categoria: o risco de suspensão no fornecimento de combustível pela empresa Raizen, em função de uma suposta inadimplência da Azul com debêntures emitidas no mercado. A própria companhia admitiu o impasse e recorreu à justiça americana para tentar evitar a interrupção do abastecimento, alegando que isso comprometeria a sua capacidade de manter a operação de pé e seguir com o plano de reorganização. Esse episódio reforça a gravidade e a complexidade do cenário em questão. Por isso mesmo, o SNA segue atuando. Desde o início do processo, contratamos um escritório jurídico especializado, com sede nos Estados Unidos, para acompanhar todos os desdobramentos da recuperação judicial da Azul. Este trabalho inclui a presença em audiências, análise técnica dos documentos apresentados pela empresa e, mais recentemente, a conquista de um espaço institucional importante. O SNA foi incluído no Comitê Oficial de Credores Não Garantidos, o chamado UCC. Quem vai explicar melhor o que isso representa e como isso afeta os trabalhadores será o nosso advogado, Bill Wider, que atua diretamente nos Estados Unidos e nos representa nesse processo. Acompanhe agora os esclarecimentos que ele traz sobre o processo.
Hello, my name is William Wilder. I'm an attorney practicing law in McLean, Virginia. I specialize in representing employees and labor unions under the Railway Labor Act. I've represented airline employees in various bankruptcy cases for approximately 25 years. Since 2020, I've represented several overseas airline pilot groups, including that of LATAM Airways, Aeromexico, Scandinavian Air Systems, and GOL. The goal of Chapter 11 under U.S. law, which may differ from bankruptcy laws in other countries, is to successfully reorganize a company to allow it to continue operating after leaving bankruptcy. What Chapter 11 also allows a company to do, once it has filed in the United States Bankruptcy Court, is to continue in control of its business and continue normal operations while it goes through the Chapter 11 process of reorganizing its debt, reorganizing its operations, and negotiating new financing that supports it leaving bankruptcy, again with the goal of continuing operations after it exits bankruptcy. So for Azul, once it filed for bankruptcy protection, as the term is used in the United States, in May of 2025, the court allowed Azul to continue in control of its business operations. This is a term known as debtor in possession. That is, it continues in possession, in control of its business operations. The court also gave Azul temporary permission to continue its normal operations, for example, to continue its important vendor relationships, such as with fuel supply companies, catering companies, information technology companies, airports to whom Azul pays landing fees, and also to continue paying its employees, funding benefit programs, providing insurance, and all the other aspects of its employees' terms and conditions of employment until the court, on a later hearing date, which is currently set for July 9, the court can give final approval to Azul to continue these normal aspects of its business operations. So the debtor continuing its normal operations while in bankruptcy is one of the core aspects of Chapter 11. Another important aspect of this early part of the case is that Azul has negotiated what is referred to as debtor in possession financing. That is loans that the company has negotiated, in this instance with note holders of the debt that Azul had issued prior to entering bankruptcy, as well as one of its large aircraft lessors, to obtain financing that it will use to continue operations while in the Chapter 11 bankruptcy process. And approval of that debtor in possession financing has been given on a temporary basis, and then it will be finally considered in July by the bankruptcy court. One of the other aspects of Chapter 11 is that it establishes what's known as the Official Committee of Unsecured Creditors, which acts as the representative of Azul's unsecured creditors. Those are the persons or businesses to whom Azul owes money, but that debt is not secured by the assets of Azul, for example, by real estate or by aircraft. It's also not secured by monies that Azul may have in its banks. So it's therefore called unsecured. Most creditors in the bankruptcy process are unsecured creditors. For example, the company's employees who may be owed money related to legal disputes are also unsecured creditors. There is a U.S. government official known as the United States trustee who selects members to be part of this unsecured creditors committee. It's made up of large creditors, those who are owed a significant amount of money and who wish to serve on the committee. The role of the committee, as I said, is to represent those unsecured creditors, all of them, of Azul. And in part of its practice, the committee will hire its own lawyers, financial analysts, and investment bankers to assist the committee during the Chapter 11 process in interacting with Azul. The role of the committee is to review the plans that Azul makes for reorganizing itself, whether reorganizing its debt or reorganizing its operations, reorganizing its fleet, to ensure that the interests of the unsecured creditors are preserved in that reorganization process. SNA was appointed by the trustee to be one of the members of this official committee of unsecured creditors. There's 7 members in total. And so that means SNA, as one of the official members, has the right to take positions in the committee about Azul's plans for reorganization, to state its positions during meetings of the creditors committee, and also to vote on what will be the official positions of the creditors committee. The committee will have access to confidential business information of Azul that other creditors will not, because it is the official representative. And the members of the committee will have the ability, in consultation with the committee's professionals, to review that information in evaluating Azul's plans for reorganizing the various aspects of its business. For SNA members, the fact that the union is a member of the official Committee of Unsecured Creditors, it means that they can be assured that the employees' interests will be given just as much standing in the consideration of the committee as the interests of other types of creditors, such as aircraft lessors or the company's fuel suppliers, or even airport authorities to whom Azul may owe monies. As part of the committee's deliberations, SNA will again have the ability to influence the committee and take positions in the committee. At this point, it's very early in the case, but as I said, the court has given Azul temporary permission to continue abiding by SNA's collective bargaining agreements, as well as continuing to pay all Azul employees in accordance with their terms of employment, to fund benefit and insurance programs for them, to pay employment taxes to the government of Brazil. And SNA's collective bargaining agreements will continue to be governed by Brazilian law. and not in U.S. law. So to the extent that there's renegotiation of SNA's collective bargaining agreements, that would only occur in accordance with Brazilian law. And as of now, to the extent that SNA has disputes with Azul over prior labor matters, those continue to be dealt with under Brazilian law. If they have been filed in the Brazilian courts, those cases will continue to proceed in the Brazilian courts. So at this stage of the case, the committee is just beginning its operations. It's just hired professionals. It hired a law firm. It hired financial analysts. It's hired aviation analysts, and it's hired an investment banking firm. And they are in the process of evaluating the debtor in possession plan that Azul has negotiated to ensure that it's not too costly to the company, that it doesn't unnecessarily incur fees to investment bankers or fees to lenders that might reduce the amount of cash available to Azul and its creditors, and to ensure that there is sufficient financing for Azul to continue operations throughout bankruptcy and ultimately successfully reorganize.
Seguimos vigilantes e comprometidos com a defesa dos direitos da categoria. Nosso objetivo é claro: garantir que neste processo de reorganização os interesses dos aeronautas brasileiros não fiquem em segundo plano. A atuação do SNA dentro do comitê de credores e com o suporte de um escritório jurídico americano qualificado nos permite fiscalizar com responsabilidade e conhecimento técnico cada passo do plano apresentado pela Azul, sempre atentos a qualquer medida que possa comprometer salários, benefícios ou condições de trabalho. Estamos à disposição para esclarecer dúvidas e reforçamos que todas as atualizações relevantes serão comunicadas por nossos meios oficiais. Seguimos juntos com firmeza e transparência. Muito obrigado.